Hi, I'm Auren, and welcome to this Paddocks Press video. During this video, I'm going to discuss the most common mistake made by trustees in sectional title schemes when trying to generate additional income from underutilised common property. During these tough economic times, it is understandable for trustees to explore the available options to create additional revenue streams in order to keep levies as low as possible. One of the best ways to generate additional income is by allowing external third parties to lease portions of the underutilised common property. This usually involves either leasing the roof of the building to cell phone companies like Vodacom or MTN in order for them to erect wireless cell phone towers, or leasing the side of a building as advertising space, or even leasing unused common property parking bays to members of the public. The good news is that these types of leases can be very lucrative, and I've seen certain leases generate tens of thousands of rands per month for schemes. The bad news is that trustees often misunderstand their rights when dealing with common property. So in order to ensure that they act within their power, it's very important for trustees to understand the effect that the Sectional Titles Act and the Sectional Title Schemes Management Act has when dealing with common property. These are the two most important requirements that must be borne in mind before starting any negotiation with a third party for the lease of a portion of the common property. Firstly, the trustees may only let a portion of the common property to a third party if authorised thereto by way of unanimous resolution. This requirement is often the most overlooked by trustees, and we find that trustees enter into these types of lease agreements without any involvement by the members whatsoever. Secondly, the sectional title legislation does not cater for lease agreements with third parties for periods shorter than 10 years. What this means is that any lease of common property to a third party must be for periods longer than 10 years, and these types of leases must be notarially executed and registered at the deeds office. The only time that the body corporate can enter into a shorter lease in respect of common property is when the lessee is an owner or occupier in the scheme. Trustees should constantly remind themselves that the common property is owned by all owners of sections in undivided shares, and therefore they cannot enter into any arrangement that limit the owner's rights in the common property without obtaining the required approval. Trustees should be careful not to rely on the legal advice received from a prospective tenant regarding the body corporate's authority requirements when entering into these important contracts, but should rather consider consulting with a sectional title specialist to avoid making costly mistakes. Thank you.